Whitfield simply says a new sentencing hearing is to be remanded for a new sentencing hearing. The 8th District read that to mean a de novo sentencing, and that's why they mooted out the other two assignments of error. I don't believe that this court meant to give a full de novo sentencing, but
so you
rather
want a clarification of Whitfield on a remand for an allied offense determination?
Yes. We read that to mean that it's limited. We read it within the scope of Evans, Saxon, and Fisher, that these issues are to be resolved on, and any remand is to be limited to only that which was found in error. And here the error is that there's more than one sentence, not that there's anything found in error of the 10-year sentence or the 8-year sentence or the 7-year sentence.
Mr. Regas, you've used all of your time.
Thank you, Edit. Thank you.
Mr. Scott.
Madam Chief Justice, and may it please the court, opposing counsel. My name is Terrence Scott, and I represent the appellee, Mr. Joseph Wilson. May it please the court, there is no error in this case, and this case should be dismissed as improvidently accepted. Further, and quite frankly, the only issue in which the state lost on appeal is the very same issue that the state concedes here today in this court. The 8th District properly applied this court's analysis in Whitfield, and there was nothing in this court's analysis in Whitfield that precluded the 8th District's manner of remand. The state seems to be focusing its argument on Mr. Wilson's likelihood of success on the issues of judicial bias and sentence proportionality at resentencing. As this resentencing has not yet occurred, the state is asking this court to issue what would be tantamount to an advisory opinion.
So, counsel, do you agree that the only role for the trial court is to have a hearing, to have the prosecutor determine what offense should be the offense upon which the sentence is imposed and served?
Correct, Your Honor. I believe the state needs to make that election. However, as the bias and proportionality issues related to a sentence that has since been vacated, the trial court should also take those issues into account when it's imposing this new sentence as they continue to be relevant.
Well, don't you think once the trial court gets, everybody back in front of it and it's there for the prosecutor to make the election, and the election is made and the sentence is imposed, and then it's up to the defense counsel at that point to make an argument to the trial court that what you just did is contrary to the judicial bias and proportionality?
Absolutely. It would be for defense counsel to raise that at the resentencing. The point is that Whitfield does not preclude this from actually taking place.
Mr. Scott, going to resentencing, because this is an issue that comes up several times, what is your position on 2919 regarding sentencing hearings? It seems to me that it says the court shall hold a sentencing hearing before imposing a sentence upon an offender convicted of or who's pled guilty to a felony, and before resentencing an offender pursuant to Section 295307, which, if you go back to that, talks about a court of appeals finding a sentence incorrect. So if I read this section, it seems to suggest that once a court has determined there's an error, there's a resentencing, and under 2919, that should be de novo.
I would agree, Your Honor. When the Court of Appeals vacated Mr. Wilson's entire sentence, the court was essentially saying that this entire sentence is unlawful. The state is attempting to paint a picture where this case is somehow in conflict with Saxon, or somehow breathes life into the sentencing packaging doctrine. And the reality is the facts in Mr. Wilson's case are wholly different than what took place in Saxon. In Saxon, the Court of Appeals vacated Mr. Saxon's properly as well as his improperly imposed sentences, where it's very clear in this case Mr. Wilson's entire sentence was deemed unlawful. It was clearly in violation of 2921.45.
But it was unlawful because because you had not determined they were allied. That's why it was unlawful.
It was, but each...
So is your position then that when you go back for resentencing, you have new mitigation, you now have all new arguments, you have new presentation of the sentencing factors, you have all of that? That's your position on resentencing?
No, I think the term de novo may not have been the best way in which the Court of Appeals could have framed this remand. But I think the Court of Appeals was very clear in that it didn't have enough information in its first viewing of the case to make a determination as to whether or not there was a proportionality and a bias issue. And since it was vacating that entire conviction, the bias and proportionality issue no longer related to that conviction.
So you don't believe that de novo means you get everything like it was a brand new sentencing hearing. You only go back for the election, and then you can raise those issues because they specifically relate to the level of sentencing?
I guess in the classic sense that de novo opens up the entire case. I don't believe that's what the Court of Appeals intended when it sent this case back. I think it's specifically intended obviously for the state to make its election, but since this was going to be a new sentence, the question of proportionality and bias were going to be questions that will continue to be relevant.
And how could the trial court address that then? In the manner in which you see this unfolding, assume that we accept your suggestion of improving this case. The Court of Appeals opinion is in place. It goes back. The prosecution makes an election. I believe he already indicated which choice he would make. Does the trial judge have the opportunity to do a redo on the number of years imposed on the crimes that are selected by the prosecutor, or are those sentences in place, and or does the judge, if that's locked in, can the judge rethink the business of consecutive versus concurrent?
Well, with regard to the proportionality question, again, it would be up to defense counsel to raise that as an issue at the resentencing. With regard to whether or not the court could adjust the numbers, it would depend, again, on the election that the state made. With regard to the kidnapping, Mr. Wilson only received 7 years. That wasn't the max sentence. So therefore, theoretically, the trial court could increase that sentence after assuming trial counsel was to raise this proportionality question, or as the court would look at that sentence, if it decided to adjust those numbers. Now, there could be a potential Pierce problem there if it's the same trial judge and this number was to increase, but that would be something for the
could the trial judge decrease it?
Absolutely, the trial judge could decrease it. Yes, Your Honor.
And isn't that what the prosecution is trying to avoid? They just want to go back, and their choice of sentence is announced to the court, their choice of which offense for which sentence should be imposed, and then everything else stays the same, including the number of years and the determination that what's left would run consecutive. Is that your understanding of what the state hopes to achieve?
Well, I think what the state is attempting to do is characterize what Mr. Wilson would have as being some sort of windfall if one of his sentences was decreased. What I would say to that is 2921.45 is a it provides statutory constitutional protections against allied offenses. And when this sentence was imposed, it was imposed improperly. And as Mr. Wilson received multiple sentences for what essentially were individual offenses, this is what was improper. So if on remand, this court the trial court now receiving this case and needing to impose a new sentence, if it concluded that under these new facts that less of a sentence would be proper, in my opinion, that's not a remand. That's what should have happened the first time around.
And it could do that. But the state believes that what should happen is just a hearing, they make a choice between which crime for which sentence would be imposed, and the sentence stays the same for that crime and the order of consecutive stays.
And what I would say, if the facts in Mr. Wilson's case were analogous to the Whitfield case, that's precisely what would happen. The difference here, though, is in Mr. Wilson's case, you have this allied offenses problem, and you also have this proportionality and bias problem. The Court of Appeals recognized that this case was markedly different from what happened in Whitfield, and they crafted a decision that reflected that difference. So hence you have this remand that at first glance does seem a little unusual, but given the facts of Mr. Wilson's case, it was what was very necessary.
Mr. Scott, did defense counsel raise the allied offense issue at the initial sentence?
The allied offenses issue?
Pardon me, please?
I'm sorry, the allied offenses?
Yes.
At the initial? Honestly, Your Honor, I'm not quite sure, because the allied offenses issue wasn't in, it's not in contention. The state has conceded that issue, so I'm not quite sure, Your Honor.
Okay. And the Court of Appeals determined that I think the 10-year sentence for robbery merged with the kidnapping. Was that, or was it the felonious assault?
The aggravated robbery merged with the kidnapping, and the felonious assault merged with the kidnapping.
Okay, so they determined the merger. And then Mr. Regas would have the Court of Appeals review the proportionality of the 10-year sentence for the robbery and the 8-year sentence for the assault. And you don't think the Court of Appeals should pass on that at this point?
That would be correct, Your Honor.
Pardon?
That would be correct.
Why would the Court of Appeals not pass on the proportionality of those sentences as imposed?
I'm sorry. Could you repeat the question? I'm sorry.
If I understand the position that the state is advancing, it is that the Court of Appeals should consider the proposition of law that the proportionality of the sentences as imposed by the trial court as to the robbery and the assault, the felonious assault, are proportional to other sentences imposed. And he thinks the Court of Appeals should pass on that. And I was inquiring whether you think the Court of Appeals should pass on that.
Well, I think the Court of Appeals was, I don't think the Court of Appeals was in the best position to make a determination as to whether or not these sentences were proportionate. The Court of Appeals,
if that's an assignment of error that's raised in the Court of Appeals, why should the Court of Appeals punt it back to the trial court?
because they vacated Mr. Wilson's entire sentence, and the proportionality related to sentences that no longer existed for all intents and purposes.
Well, had they passed on the proportionality, then the trial court could simply say, because the determination of the appellate court and the kidnapping merges, therefore there are two sentences that exist. One is a 10-year sentence for robbery and one is an 8-year sentence for felonious assault, and that's the end of the matter. And so I think what we have is the first issue as to the scope of that resentencing, and the second issue is whether the Court of Appeals has a duty to pass on assignments of error that are presented to it.
I would agree. I would agree that the Court of Appeals had a number of choices here. It obviously could have sustained or overruled those assignments of error, which it chose not to do. It mooted those assignments of error, and I think the Court of Appeals mooted those assignments of error specifically for two reasons. One, they were related to sentences that had been vacated, and two, they did not have a sufficient record before them to make a determination.
And the basis of vacating the sentence, robbery by itself, 10-year sentence for robbery, is not contrary to law, is it?
The conviction for the 10-year sentence in and of itself is not contrary to law. However,
and the 8-year sentence for assault is not contrary to law.
I would agree. A conviction in and of itself is not contrary to law. Correct, Your Honor.
Okay.
So I guess
Go ahead.
the dispute then is whether the Court of Appeals had the power to vacate the whole sentence and give the defendant another second shot at resentencing, or it should have limited its remand to remand and the prosecutor picks which of the sentences to merge, which is what I thought our case law said. You remand only to pick which offense. It's not reopen the whole sentencing. That seems to be the dispute between what the Court of Appeals did and what we may or may not have done with our current law. Is that how you see it?
That is definitely